Ready, start. The appellants took the stand that the processes undertaken amounted to manufacture, but for the deemed definition of manufacture, as noted above, the processes undertaken by the appellants would not amount to manufacture. In respect of the above processes undertaken by the appellant and no power was used, the appellants claimed benefit of exemption granted to cotton fabrics processed without the aid of power. The appellants also took the stand that since they had not used the power in respect of above processes, the benefit was available. They submitted that the use of power was only in certain ancillary and incidental areas such as mixing of chemicals, etc., and therefore the benefit could not have been denied. The department denied the benefit on the ground that there was use of power and the view was found by the tribunal. In any event, it was submitted that when the position in law was not clear and the authorities had to issue clarification, Section 11A of the Act cannot be invoked. The tribunal, after referring to the definition of manufacture under Section 2 within bracket F of the Act and the decisions of this court in J.K. Cotton's case, held that the use of power in the operation of electric motor for lifting water and caustic soda would amount to manufacture with the aid of power. In view of the decision of this court in Rajasthan State Chemicals Works within bracket Supra, the stand about the applicability of Section 11A was held to be untenable. It held that the period involved was subsequent to the decision. Strong reliance is placed on a letter of Commissioner of Central Excise dated 10/1/1999 to contend that there was doubt about the nature of the process involved. The said letter is significant in view of this court's decision. It is not known under what circumstances the letter was written. It is to be noted that the penalty amounts were equivalent to the extra demand raised, but the tribunal has reduced to it to rupees 25,000,000. Therefore, the appeal is clearly without merit and we dismiss it. Therefore, factually, the stand that there was no use of power is unsustainable. Coming to the period of limitation, the 5 years period has to be reckoned backward from 8 to 1989 when the so cause notice was issued. The Commissioner shall work out the liability and the penalty amount has to be equivalent to the amount of tax demanded.